not know about that the EXCO was not privy.
Ms. Myeni, it was never put to Mr. Designer, Mr. Sylvain Ross, or Mr. Nair that the non-executive board was not consulted and informed.
My lady, thank you, but I put it as an allegation. That is why, because I did not know that this was, amongst other things, as counsel is saying, did I share in their views?
No, Ms. Myeni.
You must have held the view in the chair. What was your view?
My view was the comparison, my lady. I did want to know what would have been the cost in comparison to what was put before us as the board to commit the company for 12 years to say, is this the only, because I can't say are these, is this the only option that we have before us? There is no other option, so that we could compare to say, is this the cheapest? Is this average? Is this the okay price we are going to be paying for the next 12 years?
Ms. Myeni, as chair of the board, if the work that management had done when they presented the proposal to you on the 31st of March was inadequate, it was your responsibility at that point to say, please bring more information to the board. You did not do that. Instead, you and a majority approved it unconditionally. Secondly, when you raise the issue with Mr. Bregia, actually you only have one issue, and that's inserting an African leasing company. There aren't wider concerns here. Those are the facts on the papers. Now, there are a couple of things in this long letter from Ms. Kwanana that I wish to point out. The first is at the bottom of page 2. On the 9th of October, a further memorandum was circulated to the board, proposing firstly the appointment of a named transactional advisor, the presentation to the board of a South African entity wishing to propose alternative funding option, and thirdly, the board again meet with Airbus urgently. Who brought the further memorandum, Ms. Myeni?
I do not know.
You don't know? Well, it wasn't a member of the EXCO, and as you said, it's highly irregular for a non-executive board member to bring a proposal before EXCO. We know it certainly wasn't the people who negotiated the deal. Who was the named transaction advisor in that memo?
My reading of these documents.
No, I'm asking you a question. It says, on the 9th of October, a further memo was circulated to the board proposing, firstly, the appointment of a named transactional advisor. Who was the named transactional advisor?
I don't have any recollection.
You don't have recollection. The presentation to the board of a South African entity wishing to propose alternative funding. Who was the South African entity wishing to propose alternative funding?
My lady, this is 21 October 2015.
You don't remember?
And a number of memoranda were circulated to the board. And this subject was quite a lengthy subject. And in various meetings, the council will recall, in all minutes, this matter was a subject. So for me to remember who was the named transactional advisor or who presented.
That's fine, but what you can remember is this. that the procurement regulations of this country do not allow members of a board simply to pick a transaction advisor of their choice and to pick a funder of their choice and to say, these are the ones we'll use. You do know that, Ms. Myeni?
I do know that.
Yes. So as a responsible chair of the board, when you get this email, the responsible thing is to say, Ms. Kwinana, we can't simply choose our own transaction advisor and choose our own funder. That is an RFP process. That's what has to run.
My lady, I had faith in my ExCo. I had faith in the executives.
So you didn't point out to Ms. Kwinana that actually it's possibly one of the most irregular things a board can do. It's not only descending into the arena as you do by negotiating with Airbus. A member of the board is hand-picking suppliers. It's not even a confined tender process. It is no tender process. It is someone going to someone they know and saying, come on board and we will give you a lucrative contract to be a transaction advisor and a funder. Now, surely, Ms. Myeni, your duty as the chairperson is to say South African Airways is subject to rigorous procurement laws. This is simply not allowed.
My lady, it's unfortunate that Kwinana is not here to answer for herself.
Your
but
reaction.
I'm continuing, Council. On my side, as the chair of the board, if I'm alarmed and seeing some governance irregularities, I wouldn't keep quiet and not address that matter, either one-on-one with the person or in the board itself. But at the same time, you, as the chair of the board, you have to balance the way in which you communicate with the rest of the people. But any governance failure, I wouldn't condone it.
But you personally went on negotiating with Airbus, which you shouldn't have done as a non-executive board member, and you kept bringing in an African leasing company for which no tender had ever been issued. You wrote to the minister and you wrote to Mr. Akum and you wrote to Mr. Bregier asking for this African leasing company when no tender had ever been issued.
I never named any supplier or any company. The proposal is the same as the A330 swap.
Well,
so I'm saying if we raised this matter, it wasn't for the board to go and look for the African leasing company. There was a due process that was tasked to the executives. And my lady, it's captured in the minutes of, I think it's the minutes of 5 March, where the acting CEO was tasked to do exactly that.
Yes,
I never appointed nor recommended nor bring any name. Now, I don't think, my lady, it's fair for me to speak for people who are not here, to answer for them, except for my role as the board member. It doesn't mean that if I don't have something minuted on these documents, it means I ignored any governance failures.
Ms. Myeni, Mr. Mayor testified that he saw you go into the Airbus meeting with Mr. Matloba from Quartile Capital. You deny that.
I deny it.
You deny that. Well, what adds credence to what he's just said is that he says there was a named transactional advisor. And our case, which I know you deny, is that that was Quartile Capital. And we'll get back to that. Secondly, the alternative funding option. You attached to your amendment application, a proposal from ostensibly from Nedbank. It's actually from Mr. Mgadi, because we later found out Nedbank knows nothing about it. Our submission is that's who the alternative funder is. It's Mr. Mgadi, so-called of Nedbank. And I'll note that it's the same Mr. Mgadi who got a very lucrative contract illegally from SAA the following year as BNP.
I'm not aware, my lady. I deny the statement. I deny that I know the Total Capital and I know that who this person was and who that person was. I deny that. Sorry, I deny the issue of Total, you say Total Capital. And I also deny that I know that Total Capital was Mr. Mgadi.
No, not Total Capital, BNP. Mr. Mgadi was BNP.
Was Mr. Mgadi here in the court to talk about BNP?
No, but it's all over the documents.
No, what I know is that Mr. Mgadi worked at Nedbank. So I did not know that he was BNP.
Well, you're going to force us to go to various SMSs on papers which prove your relationship with him, but I'm going to put that on hold for now. On page 3 of Ms. Kwinana's letter.
Yes, I have it.
She says at the bottom there's a paragraph starting, however.
Yes.
However, he also then added a rider that SAA would, notwithstanding such an agreement above, be required to pay an immediate $17 million over and above, to pay an immediate $17 million and over time further PDPs for the new aircraft. The $17 million is the PDPs that is currently due and payable. You see that? Then if you turn over the page, under recommendations, the second recommendation says there will be no penalties, i.e. no further PDPs for the original transaction will be required. So Ms. Kwinana is now confusing penalties and PDPs. PDPs are not penalties. They're pre-delivery payments for aircraft, the old ones which would now be delivered. So on page 3 she says PDPs would be immediately payable, and on page 4 she said no PDPs would be payable. And Ms. Myeni, I put it to you that this lie, frankly, and as you said, a lie is a lie, this lie that no PDPs would be due and payable should SAA try and alter the original swap transaction. You perpetrated that lie to the minister, didn't you? You told the minister after Airbus had told you that any change to the swap transaction would mean PDPs are immediately due and payable. You told the minister that the proposal that SAA had to amend the swap transaction would mean that no PDPs were due and payable, didn't you?
My understanding was if the transaction was as per the plan.
Yes.
I did not know the lie in that line.
Do you agree that what Airbus consistently said is that if you want to insert an African leasing company, then the A3, the 2002 legacy agreement immediately kicks in and the first PDPs are due and payable?
I am aware of that.
You're aware of that. After being aware of that, you told the minister that by inserting an African leasing company, no PDPs would be due and payable.
I am not aware that by inserting an African leasing company, there won't be PDPs.
Okay.
But what I know that is that there were negotiations There were negotiations that were being done, and whatever the agreement they had in the meeting with Airbus, that would...
Okay, as long as we'll now start going back chronologically, and I will show you where you were told that inserting an African leasing company means PDPs are payable, and you told the minister the opposite. But after that diversion, if we could return to the cross-examination. If we could go to page 177, volume 3. This is the letter we got stuck on last time.
Yes.
So this letter is dated 29th of the 9th. This is well after the minister's deadline to you to sign the original swap transaction. He wrote to you He wrote to you in mid-September, and he asked that by the 18th of September, the board sign the swap transaction that it and he had approved.
Sorry, Maria. It's common cause, and we've conceded many times that when the minister writes in certain instances, they will be writing to the board. And a lot of these letters that came from the minister were addressed to the board via the chair. So I don't know whether it's an attempt to confuse the witness. Yes. Yes.
Milady, I have no difficulty with the proposition that when the minister writes to the chair, he's writing to the board. I have no difficulty with that at all. He does write to the chair because the chair has a special role to play within the board. It's not necessary. Let's say that the minister wrote to Ms. Myeni and to the board to say that...
No, Valerie. They must frame it correctly. They must frame it correctly. Frame it correctly and say the minister wrote to the board. Because when you... That's the point, Valerie. Because this constant reference to say the minister wrote to you, is a distortion in itself. Thank you.
Well, we can't overlook the fact it's on page 163. 3. And it's every letter from the minister.
The High Court in Pretoria there, Dudu Myeni under cross-examination of counsel objecting to some of the line of questioning there. It's time for a short break. We'll give you a summary of that and more news after we come back. Do stay with us on Point.